Okay, welcome everyone. It's been quite a while with everything going on. Um, Lovely to have you all back. Um, I hope everyone's doing well. So today I'm going to jump into a slightly different topic. It actually covers some of the areas we've already covered. In what I've had you read in the past on Aristotle and other people and Aquinas, etc., you'll find that there's an overlap in all of these areas, and each of these speakers has covered the concept of law and jurisprudence in detail. So for today's topic, I'm not bringing up slides. I've given you a part one of what we're going to discuss. It's in two parts for this paper. The second part I'll give you before next week to read, probably a bit earlier. And we're going to cover like the philosophy of law. So the philosophy of law is also known as jurisprudence. It's really the theory behind what makes law, exploring the nature, purpose, and relationship, and how this integrates with morality and justice, and what type of society we end up with. So we have a variety of different things to consider, and of course, I'm coming at this from a very Western English law point of view, which is natural law and common law, which is the foundation of many Western countries, whether it's Australia, Canada, the United States, Britain, of course, the Commonwealth, etc. So to go over this, we can start on natural law theory. This really comes from a combination of Aristotle and Aquinas and was quite big during the medieval period. Natural law theory posits that law is intrinsically connected with morality, with objective moral principles, and these form the basis of legal norms. So natural law emphasizes the role of reason in discovering these moral truths. It asserts that unjust laws lack true authority. That doesn't mean they're not applied. And in society, law isn't always right. But the difference with natural law is that it is the foundation for what we find in modern human rights and ethical standards in many countries. Ironically, and I'll go into this in the next section, there are sections in other authors that people misread and misquote. One would be Ayn Rand. Ayn Rand, for instance, is maligned in many ways. If you look at the work Atlas Shrugged, the sort of idea here is that it's all about rich people getting richer, etc. But if you actually read it, it couldn't be further from the truth. And in this, law comes down to the just versus the unjust. So I'm sure some of you have read Atlas Shrugged. So who wants to put their hand up and tell me what section I'm thinking about? Anyone remember?
Well, which section? Could it be that large part where John Galt goes on the radio towards the end and basically explains his whole reason for doing what he's done, and that this is not about the government being able to control the output of a man, but a man having the freedom to be able to decide what is done with the product of his thought and effort.
That's
really.
part of it, yes.
Yeah.
So we also have Nagagasset, Judge Nagagasset, who retired and did this to reject collectivist society and moved over there
yes.
to Colorado. He saw one of the things we'll be looking at here is legal activism. Now, legal activism is where some judges believe that they have the right to go beyond the letter of the law and judge things based on morality. And in many cultures, this has been the way that it works, but that undermines the foundation of Western society. Can you understand why? Why do you think I would say that judicial activism in that sort of extent There might be some things where you can push it a little bit, or where juries can do things. Jury annulment is perfectly fine. But why do you think I'm saying this about judicial sort of activism?
Because lawyers are meant to interpret the law, not create law.
Correct.
Yeah.
And that's part of a divided society where we have divisions of power, decentralization in its true sense, not that what you see out there in the world at the moment, where we have an executive who has different powers and controls to a legislature, maybe a split with a Senate, and a judiciary that interprets only to apply the law, not bend it, so to speak. And it doesn't matter that you don't like it. There's a reason for that, in that sitting there saying that society isn't quick enough. Well, think about it for a moment. That's handing a lot of power to a small unelected group. You can't get rid of judges. So if a judge starts being an activist, he or she now controls a lot of power that can change the notion of what people put in. So even in a representative government where we don't vote directly, well, we have the ability to decide and change government, and things may move slowly, but that's not a problem. Nothing should move too quickly, like some of the left want, because then everything just falls apart anyway. We just test silly theories for the sake of testing. So to bring this into where natural law theory developed, it is really the heart of the common law. And just being West doesn't mean that we're all part of the common law. Germany, France, Belgium, none of these are common law countries. The big distinction here is the common law relies on judicial decisions and precedents that are set traditionally by juries, where the facts are not judged by the judge. So this is something that we've slowly moved away from in society. More and more, we have moved away from juries because the argument has been that juries can't understand complex matters. Judges, of course, must be able to, because they're highly specialized in one little teeny weeny area. See the irony of all this? So we've moved into a scenario where we start replacing the existing sort of structure of law, where we had in the past a variety of different people who would be selected. Now, many governments don't like this. They don't like the concept, of course, of giving over decisions to a group of people, 12 jurors. And the reason being is juries can nullify decisions. When you have just a judge, the judge decides both the facts and the law. So that's a different scenario than we have in how the common law basically developed. So the common law developed in medieval England. It actually goes right back to the shires, pre-Norman, but the Normans extended it. They saw the benefit of this and basically allowed them to rule England without doing too much ruling, which was a good thing for everyone because, well, government that rules the least rules the best. And common law relies on those precedents and former decisions. The way that it should be made is the foundation of those decisions, the decision of fact, gets done by the jury. And then the judge applies the law. So common law is characterized by the principle of stare decisis. Anyone want to tell me what stare decisis is? Read and looked up?
Judicial precedent or something like that, right?
Effectively, yes. So when you have a judgment, there'll be a combination of the actual meat of the judgment, as well as other parts that may be the comments of the judge, but not necessarily judgment in law. So stare decisis is a principle that then can be relied on from prior decisions. So this ensures consistency and adaptability in legal outcomes. it means that people can have an idea of what the outcome should be ahead of the time if they can apply the facts. When you start moving away from that and you end up in a scenario where the facts can be interpreted differently, certainty then disappears. So judges interpret and apply the law through case law, and this also allows the legal system to evolve in response to societal changes. So people sit there saying there's no law of Bitcoin. Of course there is. If we actually think about what the law says, we have laws for theft, we have laws covering the transmission of money. All of these have precedent. And without applying those correctly and saying that they're outside of the law, then it's either laziness by a judge or worse. We get into the worst type of activism where a judge is basically making decisions that aren't based on the will of the people, so to speak. Now, in contemporary legal systems, we have a variety of legal philosophies that underline all of the processes, and natural law is the moral foundation that helps us evaluate justice and whether a law is legitimate. Common law emphasizes judicial reasoning and the importance of precedent. So common law and natural law overlap in that both philosophies form the role of the judiciary. They guide legal education and how those jurors are trained. They shape legal reforms, address issues that might be global, challenges in multiple countries and treaties, etc., but also integrate insights from a variety of different legal systems, which, of course, helps us promote justice, protect individual rights, and respond over time to the needs of society without needing to be an activist. We can apply existing principles. One of the differences, of course, is we also have, like in the UK and Australia and the US, in the UK and Australia, we have a parliament. In the US, there's a Congress/Senate, which effectively is the same sort of role. And they act to follow the changes in society. Those who vote set the changes. Those who don't vote don't. And over time, things change. So some people complain that things don't change fast enough. But if we think about it, we haven't tested. There's no real way of going out there and exploring some of the changes in legislation that may occur. And that's where we end up with silly things where people go too far and we start getting woke society. And it's only by finding that balance that we really sort of have a system that protects property, that protects rights, etc. So to introduce the philosophy of law, then we have to start thinking about what the essential characteristics of any legal system that works are going to be. This covers law, legal rights, obligations, and the form of legal reasoning and interpretation that we will have across society. So there is this area, of course, I'm talking about it now, called philosophy of law, and there are people who are in academia, specialist philosophers who basically analyze distinctions between law and other systems of norms. So some people believe that these shouldn't be so different. An example of a person I've mentioned before, though we haven't had a lesson, would be Rawls. Who can tell me about John Rawls? R-A-W-L-S? Nope.
Theory of justice?
Sorry?
Theory of justice?
It's basically a theory of justice and natural justice. The idea is to try and have people believe that you need to look at the world as if you were blind and what would you choose and all that sort of stuff. If you didn't, yeah. And it ignores certain normal sort of concepts and aspects of humanity. I mean, when do you draw the line and do you redraw it? Because if you give 10 people an equal start and the same amount of money, then 10 different outcomes are going to occur. Some because of randomness, some because of different sort of choices. Some people will invest, some people will just go out there and have fun. And at the end of the day, after a year or 10 years, all those 10 people are going to be in completely different points of life again. One might have saved money and be wealthy, and another might be destitute. And do we then go and redistribute? If we listen to rules, we probably would. So I'm not really much of a Rawlsian. But I also wouldn't go as far as Nozick. Nozick was beyond a libertarian and believed in no intervention. I, like Hayek and others, believe that there should be a minimal government. But anyway, so some of the different areas in law, of course, include legal positivism. That would be John Austin, Hart, etc. This is a system of rules enforced by societal institutions. These are ones that are independent of moral considerations. And in this, a legal rule is determined by its source, not moral content. This is a view that actually aligns with some other cultures much, much better. For instance, legal positivism would align with certain aspects of Islamic law, or even in some countries like France, where the Napoleonic law, like civil law codes, would really integrate a different way of thinking about how rules are made. So now, if we start thinking back to Aristotle and Aquinas in natural law, then we come up with people like John Finnis, and they would argue the polar opposite to the legal positivist. That is that law in natural law form is really intricately linked to morality and ethics. Legal norms form the basis of how we interact in a modern society, and unjust laws shouldn't be considered true laws. In this, that's where we have like a right to, for instance, argue and say that this isn't correct. That doesn't mean you don't get the outcome of something. For instance, breaking the law comes with consequences, but that doesn't necessarily mean that those consequences are wrong for the individual. Who can give me an example of such a thing?
Well, civil disobedience?
Exactly. One example is civil disobedience. I may not always agree with someone like Gandhi. His views, in my opinion, were too socialist. Change needed to happen, but probably not in the way that he wanted, and he wanted it too quick. But then you have King or someone else like that who fought for change. So if we start thinking about this, then the distinction is many times that people think that they should be able to break the law, but equally not have any consequence. And of course, the problem with that is we should be looking at what consequences come from it. So as we delve into what I found is the combination natural and common law, I'll then say that this really goes down to how we apply it and whether we even follow, not just because we're doing a Breaking Bad and becoming a meth dealer, but what we find right and wrong in society. So I think someone was trying to ask a question for a second there. No, yes.
Was there anyone?
Nope. All right. Anyway, getting back to it. So this comes down to whether a law is just or ethical. And interestingly enough, a TV show that recently came on, Fallout, after a video game, had a very insightful comment, which was everybody believes that they can fix the world. They just don't agree on how. And this is part of our problem. When we have a pluralistic society, then we need to actually balance these different competing aspects. Tolerance, for instance, doesn't mean that we just accept what people do, but we don't react against it. We don't have to accept things, but we don't need to fight them either. So these different frameworks I've been talking about are instrumental in guiding the decision-making process. They shape education, as I said, but they also go into the heart of how society works. This extended beyond what people sort of understand in someone like John Duns Scotus and William of Ockham. They both talked about aspects of Christian theology that extended Aquinas, who had a synthesis of Aristotelian philosophy, and built really a system driven by both the Renaissance and the Reformation, and that were taken up by humanist scholars. So Erasmus, Sir Thomas More, these were people that, well, underscored natural law as being emphasized by human dignity and moral responsibility. So if we think about Thomas More, for instance, who can tell me what happened to Thomas More?
He was executed by the king for opposing the formation of the Church of England.
Correct. He stood up for his beliefs, and he was willing to basically die for what he believed in. At the end of the day, he would be dead by now anyway, but I'm sure he didn't want to die at the time. And sometimes there are things we need to stand up for, no matter what the consequence. This goes into other reformers like Martin Luther and John Calvin. Actually, these are people I did one of my master's theses on. Strangely enough, one of the ones that was sort of the German Reformation, etc. But these individuals, again, stood up for what they saw was morally right. And that doesn't mean that legally right. So that's the conflict of law that you find when you're looking at a combination of common law, natural law, etc. This emphasizes individual conscience and stresses a combination of personal faith and divine grace. The root of common law, of course, is something in the divine, but it doesn't mean Christian. That's something that people go wrong. Well, I might be a Christian. There are writers such as Marcus Aurelius or Cicero or any of the earlier Greeks such as Aristotle, etc., who will talk about natural law. And of course, Aristotle wasn't a Christian. He might have been taken up by Aquinas, but there was very little Christianity in someone born 400 years before Christian religions. So this gets us into the early modern phase. Hugo Grotius, who can be regarded as one of the founders of modern natural law theory, argued that natural principles are inherent to human nature. They can be understood through reason, and he then moved away from the medieval idea of integrating Christianity, saying that these were independent of religious doctrine. So this formed the groundwork for what we see as human rights and international justice today. Hobbes, Locke, and Samuel Puyndorf expanded natural law theory. I mentioned Hobbes and Locke, of course, before, and we'll get more into those. But they started addressing political and social challenges. Locke emphasized natural rights and limited government. This really profoundly influenced the liberal political thought on how modern democracies and republics work. And it underscores some of the core sort of beliefs in countries like the United States. So going back to the origins of the common law, we're tracing that back to medieval England. this is something developing as a distinct legal system. It was taken up in the Norman Conquest in 1066, where it was really a turning point. And the establishment of the King's Court moved away from the different shires to standardize principles and grab what had been ad hoc in a number of different areas, because people don't realize, but England itself wasn't England. There were many small different kingdoms before it all got put into one English sort of entity. Mercia, for instance, was a former kingdom. Anglia. So all of that got merged into what we see now. This then continued with the Plantagenets and Henry II. His judicial reforms established itinerant justices and the royal writ system. So who can tell me what a itinerant justice is? Anyone know?
Is that someone who like goes from town to town and listens to cases and then hands down a judgment, and then the townspeople can follow that judgment, and so basically they're a person of good moral standing who
yeah, correct.
listens
and this was integrated into other systems such as that in the US with the circuit court, where the circuit court would have a justice go around different courts in each of the states, hearing appeals, etc. So this formed really the heart of how the common law tradition grew. And with the Magna Carta from 1215, we started new principles of fair trial and protection against arbitrary detention. So we had the writ of habeas corpus, for instance. You couldn't just be held without, well, some reason for being held. Whereas a lot of countries in the world don't recognize habeas corpus even now. So this is a common law principle, that the right to have government not come and take you for an arbitrary reason. So the doctrine of precedent fuses with equity, or stare decisis really establishes that legal decisions made by higher courts should be binding on lower courts. So in a future case with similar facts, then if a case has been appealed, then that binds all of the decisions below it in future. So when, for instance, part of a judgment has been appealed, and a judge decides he knows better, then that just opens up another appeal. So if you don't follow that, the higher court has precedence. That doesn't always follow in reality, but the thing from in England, the Judicature Acts of 1873 to 75, both in legal and equitable principles, could then decide, allowing flexibility to the common law system. So parliamentary sovereignty in England developed through the 17th century. England was lucky in a way that it had a very early civil war. The Roundheads and the Cavaliers under Cromwell, etc., fought, killed a king, set up a republic. All that sort of stuff happened in history, and the English did it early on. Now, that may seem strange that I'm saying it's good that it was early, but as systems and society developed, France did it much later. And the problem with France doing it later is there were a lot of different ideas and technologies that allowed it to keep going too far. So rather than being reined back, as it eventually was in England, then, well, we ended up in France with a reign of terror, then Napoleon, then all sorts of fun things. So comparative analysis gives us natural law and common law being two distinct but complementary approaches to understanding and developing legal systems. As I said, natural law focuses on moral principles that should guide the creation and evaluation of law. consequently, what ethical principles make a good law or bad law. And common law relies on judicial decisions and precedents to develop and refine legal principles that then can be understood by people and allow them to understand what they would expect. For instance, contract law. Contract law has a number of foundational principles, but these have developed over many, many centuries on how you will address things. It's not like the old Norman, sort of pre-Norman laws, or the Mansgeld or something like this, where people would actually have a price for, well, fairly much everything. And over time, these areas have enabled, well, people in English and now American type of backgrounds to have trade, to develop capitalism, and to do it in a way that, well, allows people to, well, have some certainty. And no, it's not perfect, but nothing ever is, because us humans, I mean, it's the old sort of angels thing. If we were all angels, we wouldn't need a law. So, getting on to natural and common law a little bit more, the importance of these areas in contemporary jurisprudence is really that natural law offers a normative criteria for evaluating the justice and legitimacy of a law. Excuse me. It is really something that emphasizes the necessity of upholding human dignity. In the common law tradition, the reliance on judicial precedent ensures that there is a balance and stability in society, while there is also adaptability. So things change, but they don't change too quickly. It's really a more conservative approach to justice and change. It enables the legal system to respond to different evolving societal contexts, but not instantly. So these are the tenets behind law. They are critical in guiding judicial reasoning, informing legal pedagogy, which education, of course, shaping the different processes, and synthesizing the moral imperatives of natural law with the procedural rigor of common law. So William Blackstone did a lot in basically the pedagogy of this, how we form what we teach in law, what the foundations of jurisprudence are. And in our modern society, the challenges include safeguarding justice, upholding individual rights, and integrating ethical reason and judicial pragmatism so that legal frameworks are both robust and equitable. In natural law theory, as I've said, it's really about morality, universality, and human nature. They form the foundational framework for this and help underscore something that makes a society that is change, not averse to change, but doesn't just change for the sake of change, and one that can integrate moral concepts. So the proponents that we've talked about, as well as others in natural law, really say that they're objective moral principles. These are part of human nature. They can be discovered through reason. Reason, of course, not being necessarily scientific in all ways. You can't just go out there and measure all of these aspects. But with reason, we can think through issues. We can look at morality and debate it. And part of all of this, of course, is going to be looking at the outcomes. So our cultural or social context will apply, and the moral principles in our society will change over time based on that. So whereas once slavery was considered okay, in time, people start questioning it. This only happens when you have something like a natural law, common law based society. Contrary to what you hear about many aspects of the West right now, it's only that type of legal system that allowed people to question whether slaves or abusing people's freedom was right. Universality is a fundamental principle of natural law. And when people have a constitution such as that of the United States, where there's a part saying all men are created equal, universality underlies that. And over time, people will start questioning and going, but aren't these also people? And as that grows, we then have a way of challenging whether things are right or wrong. And human nature is a fundamental concept of natural law theory. Human nature is sort of the core that grounds these inherent characteristics of the law and the purpose of why we define what we put to control and limit society to stop it being too anarchic. This underlines the aspect of what it is to be human. So the characteristics include the capacity for reason, the ability to discern right from wrong, and a natural inclination to seek the good and avoid harm. So Aristotle started some of this with natural law theory. Aristotle proposed that everything in nature has a purpose or teleos, and that the good for human beings is to achieve their highest potential through the exercise of reason and virtue. Aristotle had a concept of natural law rooted in the idea that certain objective moral principles are inherent to human nature and can be discovered through rational reflection. Aquinas really took the idea from Aristotle. Thomas Aquinas extended natural law theory in synthesizing Christian theology with Aristotelian philosophy. So we really then start in the Summa Theologica to take a Christian doctrine that argues that natural law is a part of the eternal law of God. So according to Aquinas, natural law then goes into moral principles that are accessible to human reason and which are reflective of divine order. And this then extends further as we have more recent, not terribly recent, but like John Locke, expanded on natural law and the concepts of political philosophy in arguing that natural law endows individuals with inherent rights to life, liberty, and property. So they're all critical aspects. Saying that, well, we should give our property away, of course, then undermines natural law. Someone was saying something? No?
Wasn't there something with natural law and then like eudaimonia was like the goal or something? It was like true fulfillment.
Exactly. It's not, people translate it wrong. They think it's happiness. And we have things now like happiness quotient and pleasure indexes and all this stuff, but that's wrong. It's not just a fleeting thing. It's the terrible to say, but underlying principle of Bill and Ted. Be excellent. If you think about it for a moment, I mean, as crazy as that movie was, they actually got that a little bit right. The concept of being excellent was be the best that you can in whatever you do. It's part of what I always loved about certain aspects of Zen Japanese type philosophy. The idea of perfecting something in yourself. And none of us, I mean, if you actually understand it properly, you also understand that you'll never achieve that because there's no such thing as achieving perfection. But it's the striving for it. This then goes into different aspects of natural law brought in by Grotius. So again, as I mentioned before, human nature can be understood through reason. So we can think and we can determine different ideas. Puendorf integrated natural law with moral philosophy and political economy. And together, what we start seeing is that we can actually weigh things up and we can start to measure how these different aspects of society might be evaluated. Now, that doesn't mean that one person gets to sit there and say it's right or wrong. It means that as a group, we can debate and reason. And the thing with reason is we're not going to do it alone. We're not going to be like a number of Greek philosophers who love to sit in a barrel. Not going to be like the Stoic people who abandon some of these things, although modern Stoicism is a bit different. But I mean, if we look at, say, the skeptics, not what we see as a skeptic now, someone who doesn't believe, but those who abandoned everything to live sort of as hermits, etc., then we're abandoning society. So going beyond this, of course, we're going to have to start looking at the insights from both nature in human nature and purpose of law. And it's only through reason that we create a just and effective legal system. The part of the problem of this is there are competing measurements. We can't just say that one aspect of what makes society good is better. How are we measuring things? So one person might say, I want crime reduced. Fine. But what does that mean? What does that mean for other aspects of society? Does that mean that the police can kick down your door and just take someone away for questioning? Hence, habeas corpus. What do we do if that happens? In many countries, that's still something that occurs. If we think about it for a moment, it's common throughout the world. So, and it's part of what many people don't like about Western society, the fact that, well, people have rights. So, that, of course, takes us to judicial interpretation. Now, judicial interpretation, judges in a common law system, of course, play a pivotal role, but we've moved away from some of how the common law system used to work. In the past, as I noted, and this is still a large part of how things work in the US, but in England, where it was initiated, the courts have moved away in many cases from juries. They made the argument that, of course, judges know better, but while judges know better about the law, that doesn't make them someone who understands the facts. And even in complex commercial decisions, well, jury of your peers, if you want to restrict it, could be a jury of businessmen, a jury of people with MBAs, a jury of something like that. If you wanted to actually limit it to things like that, it could be someone who holds a finance degree, an accountant. I mean, I'm sure you could find 12 accountants in all of England. I'm pretty sure that would be possible. But yet, that's what we make arguments about. And if we start thinking about these sort of different aspects of what's changing, then we need to address them with reason. So when someone brings up the concept, and there are changes even now happening to get rid of some of the juries, even in criminal cases, if we start thinking about that, the reason, of course, is politicians want better sort of records of arrest and people being imprisoned. If you put someone away for 8 years, 12 years, etc., it's not going to be their problem. If they're wrongly accused, well, they won't be a politician after 20 years, so who cares? That's someone else's problem. Someone else can fix that. So this is part of the heart of why we need these sort of controls. So in understanding what justices do, we need to understand the legislative intent, previous judicial decisions, and the broader concept legally. And I know that judges, through their decisions, not only help clarify and develop the law, but when they establish precedents, they also move the law. And if they do this beyond what is reasonable, and they start acting as not just someone making a case based on extending existing principles, but adding new ones, then the ratio descendii, or the core reasoning can basically be done without, well, proper decisions. And the binding elements that guide future cases mean that those precedents are now set that change the law outside of the people who vote for it, outside of the political controls and the power structures that stop individuals abusing them. When you talk about politicians, of course, we can get rid of them. Every now and again, people react and they put a different government in. There's arguments at the moment that Labor might come in the UK. We've seen Trump go to Democrats, and who'll know next. And over time, changes occur. Unfortunately, we only seem to have governments that want to vote for bigger government, but that's life. So what we need to actually strive for is a concept of a fair and impartial proceeding. And the role of a judge is to ensure that judicial proceedings are fair and impartial. They are there to uphold due process, to allow parties to present their cases, and to ensure that evidence is properly considered. The oversight that they bring is there to maintain the integrity of the legal system. And when a judge doesn't do this, it undermines the entire foundation of our society. Now, to do this properly also means that we should have not gotten rid of juries in most areas. If we think about it, the role of the jury is to decide on the facts. And after the facts have been applied, then the judge can apply the law. Not the judge to decide the facts of the case, but the jury to decide them. So judges are meant in a common law system to operate within limitations that balance power. Judicial restraint requires judges to interpret and apply laws without overstepping into legislative or executive domains. And the adherence to precedent limits judges from making radical changes and establishing legal principles. This promotes stability. So when a judge decides that they know best, for instance, and that things are wrong, by doing this, they're taking the role of the legislature. They are undermining democratic and republican principles. It's not something that people should take lightly. So interpretive methods, judicial interpretations involves textualism. That focuses on the plain meaning of legal text. Purposism, considering the broader purposes behind a legal rule. And contextualism, which examines the broader legal and social context. So through these methods, a judge can interpret laws effectively while ensuring their decisions remain constant with existing and established principles, but also reflect the desires of society that can be there. So looking at these in depth, and these are overlapping but not compatible. Textualism is an interpretive method that focuses on the plain meaning of the legal text. The proponents argue that the words of a statute or legal document should be interpreted according to the ordinary meaning at the time of enactment. Now, that's an important aspect here. The text itself will have to be taken with linguistic precision and to respect the words chosen by the legislature or in a constitution signed off by the people. That means that you need to think of the words as they were, not as they have changed. For instance, the word terrific. I mean, the root of the word is something that inspires terror. And now we use it going, that was a terrific ride. That was a terrific movie. That comedy was terrifically funny. So we can't think of how we use it now, but how the people who wrote the text would write it. Purposism looks at the broader purposes and objectives behind legal rules. sometimes that can be used in extending things, like trespass to chattels can be taken into the digital realm. You own something digitally, so the purpose is to protect property, and if this digital item is property, it can be protected. So when a judge employs purposism, they seek to interpret a legal text in a way that furthers the underlying goals and intentions of the legislature. And when you read legislation, you will not only see the actual law, but generally there will be a preamble. And in any good legislature, the preamble will explain why. And judges can use this explanation of why to look at what the purpose of applying the law was. Then there's contextualism, which is a bit broad in my opinion. I don't go for this one, but some who are more into the judicial activism role believe that legal texts do not exist in a vacuum and that they must be interpreted through the interconnectedness of legal principles that allow judge to interpret the text in a way that reflects contemporary values and societal needs. But if we think about that for a moment, what that means is an individual gets to sit there and apply their values. We all think we can change the world. We all think we can improve it. We just don't agree how. And then we end up with someone who probably shouldn't be doing. Now, judicial discretion allows judges to adapt legal principles to the specific facts and circumstances of a case. This should ensure that a law is applied fairly and justly. The discretion is balanced between the need to adhere to precedent and the principles of stare decisis and ratio descendiendo. The methods and mechanisms allow, in a common law system, to look at different cases. And anyone who's studied law in a common law world will see many of these examples. Different judges through history have taken up this and applied it. An example would be with a telex. The example of a telex, and the case of that is looking at a message being carried across a river. Lord Denning did a case where, well, he looked at modern electronic communication, and he said, if we're talking about a communication such as that across a river, then the people on the other side of the river would apply a signal saying that they've received it, and you would see this sort of communication. Has it been acknowledged? Has it not been acknowledged, etc. So if we're receiving a fax, for instance, or a telex, has it been accepted? What is the common rule? Should that apply like the postal rule, which says once you pop it into the post, assume that it's been delivered? That sort of thing. So that allows judges to basically extend some of the different aspects of the legal system in a way that creates a robust framework that balances consistency with adaptability. And why I'm saying we still need adaptability is that there are many aspects of, well, something that is factually effectively the same, but can it be applied differently? The problem comes when people start taking it beyond that, beyond applying the same terms into completely different reasoning. So at the moment, I'm going to sort of end it at this point, and I'll go into judicial activism and its implications next lesson. And then we'll also move into the role of the judiciary versus legislative processes, etc., where we'll also cover Montesquieu and a few other people who do this. And then next time I'll also finish with the risk of, well, going into judicial supremacy. This is an area, for instance, if we look at countries like Israel, the Israeli court system has expanded into judicial activism in a big way, and the power and control of the country has been affected because of it. So this brings me to question time.
Anyone? Questions? Ask your questions. I see a hand raised by Matt. Over to you, Matt.
Yeah, it's not really a hand. They're supposed to be clapping hands, saying, I thoroughly enjoyed the topic and the lecture.
Thank you.
Did it fascinating to me, and so thank you.
Craig, I have a question,
Yes.
and it relates to the recent trial of the former US president, and in reading what has actually gone on there, it seems like that it is the outcome that has been delivered is actually a result not just of kind of an activist jury, but an activist judge as well, who has instructed the jury to interpret the law in a particular way that, to people looking in, is not congruent with the way the law should work. I was wondering to hear your thoughts on that and whether you had looked at it and.
Yes, sadly, that's one of the problems that I do see with the sort of state of the legal system as it is now, which goes back to the state of the education system, where we have mixed up education and technical training. Education should form the foundation of creating citizens. It isn't there to teach us how to be an engineer. That's professional training. It isn't there to teach us to code. Again, that's professional training. It isn't to teach us medical or other things. It is to teach us basically English, in English countries, how to read, how to understand literature, how to see the sort of things that have occurred before in our past, and to apply those to understanding society, to then take that and become citizens who can logically and reasonably debate. And by reasonably, I mean with reason. And my opinion on Trump is that he's better than some of the alternatives. But unfortunately, like myself, he needs to learn how to shut up at times, which I've been trying to do myself, but that would be his biggest mistake. He shoots his mouth off, and that causes him problems. And I can say that because I'm a person who's done that many times in my past as well. Now, the unfortunate part of this is that there are many who will see what he's done as a way of attacking him. And rather than fight fair, we have moved into a society that will use anything for power. And power shouldn't be a goal, but it is. And money isn't power the way people say. Money and power are two different things. You can be very rich and not powerful, and you can be very powerful and not rich. These are aspects of how things run that people don't always understand. In theory, Stalin wasn't rich. It was the people's money. It was the people's palace. It was the people's army that were oppressing them. Yes, that he was eating.
Yes.
So, I mean, power and money are two different things. If we look at how things were in Nazi society, then you can argue that it was very capitalist, but it wasn't. You didn't have choice anymore. You didn't have freedom of your own property. And the thing that makes property is your ability to do what you want with it. And if you didn't do what, well, the government wanted in the Nazi German sort of society, then they would take it from you, which means you're a puppet, which means it's not really control, it's not property. So again, socialist, etc. So Ruth wanted to ask a question as well.
unmute myself. Yeah, a couple of questions that might seem a bit random, but one is, would you say that the NAR and the DAR from the Bitcoin Association are kind of like a layer of common law for Bitcoin? Is that a comparison I could make or not?
They should be, yes. So they can be abused, but everything can. And there are other ways of stopping it. So people sit there and say you can't recover Bitcoin, but that's not true. Bitcoin's always been recoverable. And implementing controls over miners and others has always been there. It's just the deception that has been applied. But that doesn't mean that it's easy. Now, if we think about it for a moment, in BTC, the cost of transactions is up in the $50 US range. Now, you're not going to have any micropayments in 50 US dollars, are you? No one in their right mind would be sending 5 cents for $50. They wouldn't be storing their money in small amounts. But if we consider for a moment how things can work, in the real world, cash doesn't generally work in $1,000 notes. I don't know anyone who's ever walked into a restaurant with large notes, a small restaurant, I don't mean a really upscale one, and tried to pay. You can end up in problems. If you go to a street vendor and try to pay for something and hand them a $100 note or a £100 note, then you probably won't actually get what you want. They won't sell it to you. They may not have change. So if we start thinking about this and what it applies to the NAR and DAR, the recovery, etc., in Bitcoin, you need to actually know and be able to prove ownership and possession, etc. It doesn't just mean that's there. So for large amounts, if we're talking someone with $1 million worth of meth money or cartel money or something like this, it becomes hard to manage $1 billion or even millions of dollars in 5-cent pieces. For an average person, where your savings might be $10,000, Bitcoin's robust enough to be able to break your money down into 1-cent pieces and still have it controlled. Of course, in the BTC world, micropayments aren't possible, so that isn't going to happen. But in the way I sort of envisioned Bitcoin, then the concept was always going to be, well, lots of small micropayments, hence micropayments all through the white paper. And in that environment, there is a distinction. There's an asymmetry in money, which should be there. When you're talking about BTC's world, then it's all people with large amounts of money. It's all people running exchanges. It's all people holding all the small amounts. It's the Coinbases who basically allow you to trade small amounts because it's on their database, which is nothing new. So I'm not going to answer it fully and directly, but I want you to think about those points. The dichotomy that I'm mentioning is whether it's large amounts of money or small. And if you have people trying to take $100 at a time from the general population, that becomes difficult.
Yeah. So it applies at a macro level, not a micro level.
Exactly.
Protecting the common man who doesn't have much.
Yes.
Yeah.
Exactly. It doesn't protect the drug dealer. It doesn't protect the bank who has been sanctioned. It doesn't protect the corrupt government official. That's the distinction people aren't getting. It does protect the average person because police work is expensive. And to go out there and trace some guy selling baggies on the street, the last 20 he did, well, not gonna happen.
Very good. Could I ask cheekily one more question, which is probably far more annoying? how do you think that the legal system is going to stand up to the advent of AI? Like, for instance, if we have an AI that develops a 1,000 IQ, let's say, does it also gain any rights? And does the idea of slavery apply? And also just moral responsibility. You can't put an AI in prison. So who do we attribute blame to?
You could turn it off, but you're talking about a general AI, and
Yeah.
I still don't believe there'll actually be one in my lifetime. Contrary to what a certain Tesla sort of creator goes around running and saying, AI is dumb. It is machine learning and statistics, and by any other name. And large language models may seem to be smart, but they're really not. They can't judge, they can't actually put any insight or reason into things. So that
they
distinction
can't own property, they have no personhood, and they have no rights. No. Okay.
Well, because
They're not
they don't
conscious. They can't think.
Yeah, they don't reason. They can answer you badly, and you can set them up so that they seem to reason, but they're no closer to passing the Turing test, in my opinion, than they were 50 years ago.
I saw a great comment on AI just yesterday, and it was someone said, I want AI to be able to do the dishes and take care of the laundry so that I can have free time to write and do art. I don't want AI to do my writing and my art so that I can have time to do the dishes and the laundry.
Oh,
and I
which
think
is the way it's
we've got to
going.
ask about. Yeah, completely.
Actual ignorance, the way I look at it, has a purpose. It can do certain things very well, but it doesn't do anything new. Contrary to what people say. You might be able to say mash X and Y together, but it's still not new. None of the art created by Dali is new. It is derivative. So there are, if you go around and you walk around town in London, you will see thousands of examples of paintings that sort of look like other artists, sort of Picassos and sort of Monets that have been derived, but all they're doing is copying. They haven't created, and that's the distinction.
And what about when they work together? Humans and AIs
Wait.
work together.
I want to move over to Matt. I want
Sure.
Matt to ask his question. Sorry, Ruth.
Yeah, I didn't have a question. I was just gonna make a comment on Ruth. I think it seems to me like the AI is an example of what Dr. Wright was talking about with the contextualism, and things change, but it's not really anything new. I think if you took it down to first principles and precedent, then the laws that are going to apply to AI or, new things with blockchain and property rights will be the same. But I think one of the words you used in the presentation was when these changes happen, people try to impose, contemporary values on it and then new morality. And I think that's one of the ways, people try to take power and control over these things when they're new, when it should really just, if you just look at the same virtues and values are going to apply to AI or blockchain or everything throughout history.
Yeah, if I'm wrong and an AI becomes a general AI and starts to reason, then I'll address that. But right now, they don't. Humans, of course, they're a tool. So like every other tool, they'll change how things are. But what they will do is take human reasoning and make certain aspects of what we do easier. At that, I'm going to leave you for the evening, and I hope you continue to chat, and hope you enjoyed, and we'll continue with this topic next time.
Right. Thank you very much, Craig. If everyone
Thank you.
thank you and stick around for a couple of minutes afterwards, please. Thank you, Craig.
Thank you.
Thank you.
Before we stop recording, the main topic of the discussion today was natural law and man-made laws. And in the concept of Bitcoin, there are parallels. We can say that the natural laws of Bitcoin can be considered the protocol, and that the protocol, and on top of the protocol, there are man-made laws which apply, such as theft, fraud, and similar things. You've all got a good idea and grasp of what the protocol is as the natural law, and also, as was discussed by Craig, there are people interpreting the laws in their own ways. And we've seen this throughout the last decade or so, where people interpret Bitcoin in their own ways, whereas they should apply the natural laws and apply the man-made laws, and then interpret apply the man-made laws on top of whatever they are doing. It's when people do not respect the natural / protocol laws and interpret and try the man-made laws and try and create their own man-made laws, e.g. where we get coders law and that they have a right to steal because the code allows for it, etc. That's where people get into trouble. So if people were understanding and applying the philosophy of law more readily upon their projects, and this happens in BSV land also. I'm thinking of HODL Locker, which recently Relay X has done a disappearing act, and there's been some losses there from what I've been reading. That is just an example. There are other examples in the BSV space which stuff has happened. But this, again, is where I'm saying natural and man-made laws. This is where man-made laws apply, where they've been following the natural protocol laws, but they've been doing their own interpretation of man-made laws, where if they disappear and they've said, given fair warning, we might disappear and disappear with all your funds. I think some of them gave warning. I don't think some of them did at all. This is where problems happen, and people can create businesses and businesses fail. It's very rare to see someone create their first business and for that first business to succeed and grow into the future. Often people fail at least one time, and then they learn and grow from that. If people apply the laws to themselves and then they give themselves room to grow and prosper in the sector and space they are in. Anyway, I will leave you with those parallels, discuss in Slack, read the rest of the paper for next month.